Hello, my name is Zachary Jernigan, and today I'm going to be presenting evidence on behalf of the plaintiff in the case of Artikal Sound System versus Warner Records. My client, the Florida-based reggae band Artikal Sound System, is suing the international record label Warner Records for copyright infringement of their song, Live Your Life. To give you a brief background on the dispute, the British recording artist Dua Lipa wrote and recorded the song entitled Levitating in 2020, which was published by Warner Records. After a significant fan response to Lipa's song online, many independent users found striking similarities between Levitating and my client's original song, Live Your Life, which was released only 3 years prior. Today, I will prove 4 major claims in this case. 1. The two songs are similar enough to establish the claim of copyright infringement overall. 2. The producers of Levitating had access to my client's song prior to Levitating being released. 3. Individual musical components within Levitating were copied from Live Your Life. And 4. Lyrical phrases and rhyme schemes were copied from Live Your Life. Let's begin with our first claim, that the two songs share a general similarity. A simple musical analysis shows that these two works share an identical key, B minor, a near-identical chord progression in their hooks, an identical rhythm structure known as the Charleston, and tempos which are within 5 beats per minute of one another. Now, it might be difficult to argue that any one of these similarities warrants litigation, but when two songs share this much in common, it creates two sounds that any reasonable person would consider derivative. This legal precedent was upheld in the Blurred Lines case of 2016, where the creators of the song Blurred Lines settled out of court and paid $5 million to the Marvin Gaye estate. And while all this may be subjective, the 1946 case of Arnstein versus Porter established the precedent for determining what's referred to as substantial similarity. 1. There must be evidence that the defendant had access to the copyrighted work. 2. There must be evidence that the works are substantially similar. The latter of these two standards is obvious in the fundamental similarities in the orchestration of these two works. The first standard will be proven in my client's next claim. That claim being that, that the producers of Levitating, including Miss Lipa, had access to my client's song prior to the recording of the song released by the defendant. Beginning in 2017, my client began posting their song Live Your Life on multiple platforms online, and is even still available to be listened to today on SoundCloud.com, which has a posted release date of March 29, 2017. This means that Lipa and her associates had free and reasonable access to my client's song long before Levitating was released. The precedent of access established in 1946 was upheld in 1976 in the case of the Chiffons versus Harrison, where George Harrison was forced to pay damages for the use of the melody of the Chiffons' He's So Fine in his song My Sweet Lord. Moving on to our third claim, that individual components within Levitating were copied from Live Your Life. Once again, a musical analysis of both works, even when separated from the overall tone and feel of the song, shows similarities. In both songs, the hook, which is the part of the song that is meant to be remembered easily by the listener, contains near-identical chord progression. The first 3 chords in the hook of Levitating are the exact same as those used in the hook of Live Your Life, leaving only the 4th part of the progression different between the two songs. In 1992, similarities between chord progression was the determining factor in the case of the Hollies versus Radiohead, where the former successfully sued Radiohead for a share of the royalties to the song Creep, as it contained similar chord progression to the Hollies' The Air That I Breathe, released in 1974. For our final claim, I'll remain focused on individual musical components within the two songs, this time focusing on the lyrics. I'd like to point out these lyrics in the defendant's song. I got you, moonlight, you're my starlight, I need you, all night, come on dance with me. And I'd like to compare them to a phrase in my client's song. I've got to live my life. I've got to live my life all day, all night, party till the sunrise now. At first blush, these may seem like completely different sentences, but when you consider that these phrases occur within the same rhythm within the song and even share a similar melody, it's easy to draw parallels. I've got you in the first song, and I've got two in the second song. Moonlight countered with my life, all night versus all day. The last parts of both phrases are the least similar of all and yet still maintain the theme of dancing and nightlife. There is legal precedent for suits of this nature coming about from lyrical similarities. In 1973, the case of Levy versus Lennon saw John Lennon settling out of court with the copyright holder for Chuck Berry's You Can't Catch Me, citing that Lennon's song, Come Together, was not only musically similar, but also contained a single similar lyrical phrase. Now, before I conclude my statements, I'd like to address some of the common arguments against my client that the defense may be presenting. First, they may claim that their work cannot be derivative of Live Your Life because it was inspired instead by the 1998 song Rosa Parks by Outkast. In a 2018 interview with the British entertainment website NME, Dua Lipa mentioned the group Outkast when talking about influences for her upcoming album, Future Nostalgia, which would contain the song Levitating. With that in consideration, we can look to the similarities between Levitating and the song Rosa Parks. Once again, the same chord progression in the hook, but in a slightly different key. The problem here is that according to prior legal precedent, it doesn't matter if the work was meant to draw inspiration from another work. Going back to the Chiffons versus Harrison, during his decision, Judge Richard Owen stated, and I quote, "Did Harrison deliberately use the music of He's So Fine? I do not believe he did so deliberately. Nevertheless, it is clear that My Sweet Lord is the very same song as He's So Fine with different words. And Harrison had access to He's So Fine." End quote. Returning to this case, the situation is the same. Whether intentional or not, a derivative work is still infringement. Another claim the defense may level is that the unique theming of the song qualifies it as a transformative work and is fair use. While it's true that the overall themes put forth in both works are distinct, Live Your Life being an anthem of seizing the moment and Levitating expressing the felicity of romantic love, the 2014 case of Petty versus Smith saw Sam Smith settling out of court after being sued by Tom Petty and co-writer Jeff Lynne after they found similarities between the melodies of Smith's Stay With Me and Petty's 1989 classic, I Won't Back Down. When taking the two songs together, there are virtually no parallels in message or theme, and yet Sam still had to award Petty and Lynne with a 12.5% writing credit. The same is true for the defendant in this case. The pronounced musical similarities disqualifies it as transformative and can only be considered derivative. Finally, it's possible for the defense to argue that the amount of derivative material used in Levitating is too small to be considered infringement, but once again, prior cases do not support such a claim. In 1997, the case of The Verve versus Klein, where the UK-based rock group, The Verve, failed to acquire the rights to sample the orchestral version of The Last Time by the Rolling Stones. Klein, the then copyright holder, sued, leading to the Verve settling out of court and relinquishing all royalties to Klein. This outcome supports the idea that a work need only use a small piece of someone else's orchestration to constitute infringement, and everything that we have seen in this case so far shows that Warner Records published a song that used far more than one small piece. To sum up the case on behalf of the plaintiff, we maintain that 1. The two songs are similar enough to substantiate the claim of copyright infringement overall. 2. The producers of Levitating had access to my client's song prior to Levitating being released. 3. Individual musical components within Levitating were copied from Live Your Life. And 4. Lyrical phrases and rhyme schemes were copied from Live Your Life. We refute any claim that 1. The influence of any other work discredits the plaintiff's claim of infringement. 2. The unique theming of the song qualifies it as transformative work and is fair use. And 3. That not enough of the original work was used to consider it derivative. We base these arguments on legal precedents established by William Thick and Harris versus Bridgeport Music Incorporated and Gay, Armstein versus Porter, the Chiffons versus Harrison, the Hollies versus Radiohead, Levy versus Lennon, Petty versus Smith, and the Verve versus Klein, as well as interviews given by Dua Lipa and all musical works brought into question during these proceedings. With all of this in mind, the only verdict that this court can render is one in favor of the plaintiff, Artikal Sound System. Thank you.